Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals navigating separation and divorce. So whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we're here to provide clear and practical insights. Today we're diving into a question that catches many people off guard. Can your spouse or former spouse claim part of your pension years after the divorce is finalized? When couples divorce, dividing assets is usually a major concern, and pensions are often part of that equation. Under Ontario law, pensions are considered family property and can be divided as part of the equalization payment. But what happens if years go by and then suddenly one spouse demands a share of the pension? Is that even possible? The Family Law Act sets clear deadlines for making equalization claims. 1, 2 years after the divorce is finalized. 2, 6 years after the date of separation if there's no chance of reconciliation. And 3, 6 months after the death of a spouse. Well, it seems straightforward, right? But things get tricky when we factor in the Pension Benefits Act, which sets minimum standards for Ontario pension plans and can override other laws unless explicitly stated. Let's break this down through real-life cases to understand when a late claim might still, in fact, have a chance. In the case of Johnson v. Johnson, a 2012 case, the Ontario Superior Court of Justice ruled that pension division claims are subject to the Family Law Act's 6-year limitation period. The case centered on a claim under the Pension Benefits Division Act, but the court made it clear this federal law doesn't stand alone. It works hand in hand with Ontario's equalization laws, meaning once that 6-year window closes, so does the door to claim pension entitlements. So if you're thinking about making a claim for pension division, timing is critical. Waiting too long could leave you without any legal recourse. The importance of acting within the legal time limits was reinforced in Romatar v. Romatar, a 2020 case. Now, in this case, an application for equalization, including pension entitlements, was brought 13 years after separation. The court dismissed this application, ruling it was statute barred under Section 7.3 of the Family Law Act. The judge didn't cite the limitation period. The applicant also failed to provide any evidence that they were actually entitled to an equalization payment. Without proof and the deadline long past, the court saw no grounds to grant relief. What can we learn from these cases? Even if you bring a claim on time, you need solid evidence to back up your entitlement. 1, know the deadline. You have 6 years from separation to file for equalization. 2, gather evidence. Prove your entitlement to a share of the assets, including pensions. And 3, get legal advice. Consult a family lawyer to make sure your rights are protected. In Birthwam v. Birthwam, the court allowed a pension claim to proceed despite years passing and a foreign divorce. This was a 2002 case. And in the Campbell v. Nickel case, a 2016 matter, the court extended the limitation period when delays happened because of procedural issues and good faith attempts to settle out of court, especially since the delay didn't unfairly harm the other spouse. In some cases, pension rights survive divorce. In Smiley v. the Ontario Pension Board, the court ruled that a divorced spouse was entitled to survivor benefits because those rights vested when the first pension installment was paid, not at the date of divorce. This case shows how crucial timing is. Even after divorce, survivor benefits might still apply if they vested before separation. The court also has the power to protect assets for equalization payments even years after divorce. In Chi v. Wang, a 2010 case, the court ordered proceeds from selling the matrimonial home to be held in trust until the equalization claim went to trial. This prevented the dissipation of assets, ensuring funds would be available if the claim succeeded. This shows how courts can step in to preserve fairness, that is, freezing assets, so that a spouse has a chance to get what they're owed. Well, what do these cases teach us? While the 6-year limitation period is very real, it's not always the end of the road. If you have a valid ground and acted in good faith and your claim won't cause undue harm, the court might give you another chance. But the sooner you act, the better. What can we learn from these cases? 1, know your rights. Understand pension vesting dates and equalization rules. 2, act fast. Don't wait. File your claim within the 6-year period if possible. And 3, get legal support. A family law lawyer can help you navigate deadlines and exceptions. Now, as we've seen, Ontario courts carefully balance the rights of both parties when deciding whether to allow pension claims years after a divorce. While the Family Law Act sets clear limitation periods, the court has the discretion to extend those deadlines in specific circumstances, like procedural delays or attempts to settle out of court. But it's not always straightforward. Finally, in the case of Janikowski v. Janikowski, the Ontario Superior Court denied a late pension claim because the husband had declared bankruptcy and the wife was treated as an unsecured creditor. This ruling highlights a critical factor. Bankruptcy can completely block any equalization claim, no matter how valid it might have been otherwise. So, can an ex-spouse claim part of a pension years after divorce? The answer is, it depends. Success hinges on the factors like the timing of the claim, the reason for the delay, and whether granting the claim would unfairly harm the other party, and the impact of financial events like bankruptcy. If you're in this situation, consulting a family law expert is crucial to understanding your rights and options. Well, that's it for this episode of Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.